So welcome everybody to our first QMUL Law Alumni Series seminar for the 2021-2022 academic year. I'm Mario Mendez, a reader in law at QMUL and a QMUL Law alumni myself. This series was conceived as a way for us to nurture our links with our alumni and to keep us engaged with each other. Our schedule for our first semester of this academic year is on the PowerPoint that I hope you can all see. So our November seminar will be given by Dr. Saskia Hufnagel and our December seminar by Professor Eric Hines. The URL at the bottom provides the details for signing up to our forthcoming seminars and also has the links to the videos for the seminars that took place in the 2020 to 2021 academic year, with the list of speakers at the bottom of the PowerPoint. Turning now to our seminar and speaker for today, it is a great pleasure for me to introduce my colleague, Merris Amos, who is Professor of Human Rights Law at QMUL. She will be discussing state duties and the protection of human rights. Merris has published widely in the field of human rights, and her book on human rights law, now in a recently published third edition, has become an important reference point for scholars, students, and practitioners. She's a member of the executive committees of both the UK Constitutional Law Association and the International Association of Constitutional Law. She's a long-standing member of the department and has been teaching popular human rights courses at undergraduate and postgraduate level, as well as teaching on other subjects such as our public law module. She has supervised many LLM dissertations and PhD students, so she will be well known to many of our alumni. Now, before passing the virtual floor to our speaker, a quick word on the format for today. Merris will be speaking for about 30 minutes or so, which will be recorded, and then we go to our Q&A session of around 20 minutes or so, which will not be recorded. And during that Q&A session, the audience are free to ask questions directly themselves, so can pop on screen to do so, or just turn their mic on without having their camera on if they wish to ask a question. Or if you prefer, you can use the chat function, and I will also read questions out for you. Or you can even pop a question into the chat before we get to the Q&A session if you think of a question that you would particularly like to ask. Now, can I remind the audience to please keep their mics off during the presentation itself? Thank you very much. And Merris, please do start when you are ready.
Great, thanks, Mario. I'm going to share my screen hang on just make sure I'm sharing the correct screen with you. Great. So thanks very much, Mario. Yes, I have been at Queen Mary for quite a while now, and I think it's coming up for 15 years. And so I may well have taught some of you. And so thank you for coming along today. I really hope you find it interesting. State duties and the protection of human rights. This is something we don't often talk about. We don't often talk about the correlative relationship between rights and duties. And it's something that I became interested in because during the pandemic, I was struck, I think we were all struck by the gravity of the situation right at the start, but it seemed a lot of decisions were being taken that were crossing over with our human rights protection, but there was a real lack of knowledge about what duties these rights involved for the state. And so my thinking about this, I was not alone in thinking this. Earlier on this year, in February, the NGO Liberty published its Coronavirus Rights and Support Bill of 2021. And I expected, it had the word rights in the title, I expected this to be a bill that was an extensive list of rights, human rights that were relevant to the pandemic. But it actually contained duties. It was much more focused on specific duties on the state. So in this bill, there was a COVID data protection duty, a duty to secure an adequate standard of living when self-isolating. There was a duty of financial assistance during school closures, and a duty about providing meals, free school meals to children during school holidays. So Liberty, campaigning organisation for human rights, had picked up on this. Well, duties are really important as well, and this change in direction, this change in thinking from rights to duties. And so as I thought more about this, I realised that the state duties generated by human rights are very often neglected, and I'm guilty of that as well. Teaching human rights law, I often start, we have a brief discussion: what are rights, what are human rights, rights impose duties, like according to Hofeld, the classic correlative relationship between rights and duties, and then we just forget about that and we move on to talking about the scope, the content of rights, when rights can be interfered with. So these state duties are often neglected, but then the pandemic in particular exposed that it's really no longer safe to assume that because we may have human rights that we take seriously, that the state is also taking the corresponding duties generated by human rights seriously as well. And it's not just the pandemic, there's a number of other examples. If we go back, Grenfell, the Grenfell Tower disaster, for example, the deportation of the Windrush migrants, these really large-scale violations of human rights, which can, in essence, often be traced back to the state not taking those duties seriously. So my theme is this stronger focus on state duty is necessary and important to the protection of human rights, and I hope to convince you of that, and I hope to look at some ways that other jurisdictions have tried to improve knowledge, recognition, have tried to force the state to take its duties more seriously. First, we have to think about, well, why don't we take state duties seriously? And it's very clear that the state is, of course, not the only duty bearer when it comes to human rights. There are lots of other duty bearers, individuals, you and I, for example, maybe corporations. But if we bring it back to what is at the core of human rights protection, you have to appreciate that the state is the most important duty bearer. But we need to be, when we think about duties, we have to be realistic and clear and honest about burdens and justification and allocation. If we have a right to life, for example, what kinds of duties does that impose on the state? How much is that going to cost? Which particular institution of the state is going to bear the burden? If we take state duties seriously, we also have to think carefully about the barriers to upholding rights. What kinds of barriers might there be? There might be corruption in the system. There might be problems with access to justice that make those duties not taken very seriously by the state. We also have this complaints-led model in our Human Rights Act, where we rely on an individual victim to bring a claim that their rights have been breached. If they're going through the legal system, if it can't be resolved prior to some kind of litigation, that's a very lengthy process, and often the remedy will only apply to that individual person. And this means that often large-scale violations are not addressed until it's too late, because the one individual victim didn't bring their claim, or perhaps the relevance of that individual's claim was not picked up, the relevance of that claim to lots of other similar claims. Taking state duties is important as well in the climate change context, and there is a lot of discussion in academic journals about the state owing duties to holders of human rights who haven't been born yet, future generations, this notion of intergenerational justice. So taking state duties seriously is important also, because if they're not taken seriously by the state, what we're relying on is the state doing the right thing. Can we really trust the state to act morally if it's not under a strong and enforceable duty? And I think some of the events we've seen over the past couple of years start to question whether the state really has our best interests at heart. So the next question is, we know it's important. We know we should be taking these duties generated by human rights more seriously, but we have to ask, well, why don't we? Why don't people talk about this more? And I was really struck by the fact that there's not a lot of discussion of the duty side of the human rights state-duty relationship. Well, firstly, you could say the human rights movement has got good PR. It's very trendy. It's got a lot of political significance. Everyone's really interested. My students are really engaged when I talk about human rights. If I said, oh, let's talk about state duties instead, they might not be so engaged. It's also true that talking about duty is very difficult, and it is often not much fun. Duties are really a complex problem. If you think about the right to life example I was utilizing before, thinking about where all the burdens lie, the resources involved, who bears the burden, how should the duty be determined? Is it a duty of reasonableness? Is it a duty of proportionality? So there's all these particular issues that make talking about duty important and difficult. But we also have the problem that's often overlooked, is that states are not really committed to making their duties clear. And ever since the time of writing down duties that correspond to human rights in international instruments, this has been an issue. And it's very interesting to look back to the drafting of the Universal Declaration on Human Rights in 1948, and how many of the NGOs and associations of lawyers that were contributing to the drafting process had insisted that the human right be framed not only in terms of the right holder's entitlement, but also the state duty to protect that right. And there's an organization called the American Law Institute, and its Statement of Essential Human Rights of 1945, which was actually very influential in the drafting of the Universal Declaration. Every right was accompanied by a duty on the state, and they also had this incredibly comprehensive explanatory document explaining exactly what the state would have to do in order to ensure that the basics of that particular right was upheld. None of that made it into the Universal Declaration. The American Declaration, the Rights and Duties of Man in 1948, which actually predated the Universal Declaration by 6 months, the drafting process was similar, although the history, those who've written about the drafting process have focused a lot more on the removal of any state duties from this instrument. And so there was a real pressure to remove anything that was too onerous or too demanding of the state. And a lot of those articles were replaced with duties on individuals. And we now see today there is a similar fascination with imposing duties on individuals and imposing duties on corporations, but being a little bit vague and unformed when it comes to articulating the duties on the state. So another problem when you start to think about state duty in this context, as I've already said, it is actually a very, very difficult thing to pin down. And so it's important to have some kind of framework for thinking about state duty and human rights. And there is quite a lot of philosophical literature on this, and you'll be absolutely delighted to learn that I'm not going to talk about that today because you might all die of boredom. But I'm taking the best bits, which is incredibly useful to think about state duties. I find it very useful, and it's from some Kantian thought, if you want to delve further into this. And it's this distinction between the perfect state duty that is determinate. We know what it is. For example, the state a prohibition on the death penalty, that's a right to life issue, relatively determinate. You can enforce it with the law. It might be enforced, or it's possible to enforce. It's all very clear. We contrast that with the imperfect state duty, which is in some way incomplete. There's something wrong with it. It might not be clear what the duty is. There might be barriers to enforcement. It might be too complicated. Nobody knows about it. Nobody takes it seriously. So I take an enforcement view and say, if the human right can be enforced and that duty which is imposed on the state can be upheld and imposed, and the state takes it seriously because it will end up in court, we call that this is a perfect state duty. And you can further divide those, as you'll see in a moment, this will make more sense, into the universal and the special type of duty. Sometimes students ask me, so what are we getting at? What's the purpose? Why are we doing this? Why protect human rights in the first place? Why impose duties on the state? Why strive for perfection in state duties? And the Kantians would say it's all about rejection of injury, making sure that we're all safe from mental and physical harm. So that's all I'm going to talk about in the philosophical context. If you have any questions, of course, ask me in the questions later. So I'm now going to talk about, well, how does this work in the UK context? What kinds of duties are imposed on the state? What kinds of universal duties? These broad, non-specialist, could cut across all areas of law, all types of activity. So of course we have the duties generated by the Human Rights Act, the common law, by statute, and by international law. And when we look at this system that we have imposed, we see that there are a number of imperfections with our duties. Firstly, is the extent of the duty. What does the state have to do exactly? And it's not set out in the Human Rights Act. All of the elements of the right to life, for example, the prohibition and is there, but the duty to safeguard life, the positive duty, the duty to investigate is not there. And so we're relying on the courts to fill in the blanks. But often there is confusion in public bodies such as the police about, well, what is our duty in this context? We really don't understand this. And we've got lots of examples of that in the case law, the very high profile judgment in DSD about the black cab rapists and the failure of policing and the duty to investigate. There was untold confusion about what that duty entailed in that particular context. There was also disagreement in the judges of the Supreme Court about what the duty was. There's confusion over what the right to life entails for everyday policing. How can police keep women, for example, safe? They're not really sure. There hasn't been an appropriate case providing the guidance. So relying on the courts is not perfect. We have lots of blanks where the state body might not understand its obligation. Of course, for those who have been law students, you'll understand the doctrine of parliamentary sovereignty. So the Westminster Parliament is under no perfect duty to act compatibly with human rights. Of course, there are provisions in the Human Rights Act to deal with legislation incompatible with human rights, but Parliament can override that should it choose to do so. Parliamentary sovereignty and the nature of the UK as a dualist state also means that lots of international human rights law, such as lots of economic, social, and cultural aspects of international human rights law, that's not been incorporated into our legal system has a very limited impact. One of the greatest barriers to perfection of our universal state duties is access to justice, as I've already mentioned. And the notion in many public sector decision makers that the prospect of litigation is unlikely, even more unlikely 21 years after the Human Rights Act came into force than it was at the start. We've also seen over the past 20 years a real decline in the culture of human rights and the importance of human rights in public sector decision making. It's no longer taken seriously. So the universal duties, there's a number of imperfections, but we mustn't forget that there are also lots of special duties in the UK context. And this is a huge range and variety of laws imposing duties in response to human rights issues, or issues which could be construed as human rights issues. And you can see them constantly before Parliament now. There is a huge range of legislation. It's a new fashion where the legislation is imposing duties on state bodies. And these are very specific in particular contexts. So one example is the Domestic Abuse Act of 2021, which is very recent, establishes the Domestic Abuse Commissioner, who's under a duty to encourage good practice in the prevention of domestic abuse. And there are a number of other duties provisions in that act. Another example that is something that we're all aware of in the higher education context is the Higher Education Freedom of Speech Bill, which is currently before Parliament. Now, this is a good example of what the special state duty is capable of in boosting what is seen as a problem. So government has identified a problem with a particular right, freedom of expression in the higher education context. And so it's decided that that right needs a boost. We need to make sure that this duty is clear and enforceable. And so there's a huge variety of duties in this bill. Freedom of speech for staff members, are duties imposed on universities. So freedom of speech for staff, for visiting speakers. And there's a massive increase in penalties as well, far more than would be recoverable under the Human Rights Act. So these special duties can be very useful. They're a very useful way of making the state take its human rights duties more seriously. However, relying on them extensively is problematic. They are often reactive, not proactive. And so often you will see these duties and this special regulation come into play following a terrible disaster. So, for example, there is currently the Building Safety Bill before Parliament in response to the Grenfell tragedy. There is also a consultation on enhancing protection in large publicly accessible spaces, which is in response to the Manchester Arena terror attack of 2017. So there's this like waiting, lots of people can foresee that there is an area where the state needs to take the right to life, these two illustrations, more seriously. Lots of people have been making complaints that the disaster happens, and it's not until the disaster has happened that the regulatory environment is improved and the duty comes into play. And it's also a conversation that's being had about the pandemic at the moment, and whatever's recommended in the future in terms of regulation to avert a similar disaster. The other problem with these special regulatory duties is, as you can see from the Freedom of Speech Bill, they can often be quite politically motivated, and in some instances they can be used to curtail, to make less generous what might otherwise be a fairly generous human right to a more that would operate across the board. So it's easy to see that in the context of a couple of examples. The Overseas Operations Act of 2021 has been designed to limit the liability of the armed forces, the UK armed forces, operating abroad in an overseas context. So it's designed to ensure their liability is not as great as it would be if it was just the Human Rights Act that was regulating their behaviour. So the Overseas Operations Act is being used to define the duty more narrowly. And similarly, in the immigration context, Part 5A of the Immigration, Nationality and Asylum Act has also been designed to limit judicial discretion in the context of immigration. So we can see from the universal and the perfect and the special duties that we're a long way from perfection in how the state conceives of its duties. And the next question, and what I'll focus on for the remainder of the talk, is, well, how are we going to improve this situation? One answer is what I was just talking about, targeted regulation. So you take all the really serious problems we can see. Climate change is a good example. And we ensure that there is a really strong regulatory environment that is making sure the state takes that duty particularly seriously. But the problem with that is, can anybody really imagine all the potential risks? Some are very obvious and obvious candidates for regulation, but others are not going to be foreseen. So I'm not dismissing regulation or targeted regulation. I think that's a very good way of dealing with this. But another way is to try to improve the universal duty, to try to improve these duties generated by human rights law across the board. And you can look around the world for examples of how different countries deal with this, but we don't have to look very far, because the most modern and progressive approach is actually at the moment happening in Scotland. And Scotland is in the process of developing a Bill of Rights. The Scottish government is very much on board with this. And an aspect of that is a really strong focus on duty. Of course, there's a huge range of rights that they're going to include in their Bill of Rights, but they also have taken much more seriously the notion of the duty, that is the corresponding duty imposed on the state. So there are three strands to what's been suggested in Scotland as a way of making the state duties more perfect. And the first is the practice of monitoring, enforcement, and building a culture of human rights. Access to justice is a huge part of that. If people can't bring these types of claims to court, the state obviously won't take its duty seriously. In Scotland, they've also proposed there's a duty on government to publish a human rights plan, and they put a special focus on human rights monitoring bodies. So for the UK as a whole, it would be the Equality and Human Rights Commission. In Scotland, they have their own Human Rights Commission. And an important part of that is the provision of guidance. So specialist bodies sitting down with state decision makers and developing rights appropriate guidance, and what that public sector decision maker should be doing in that particular context to make sure that rights are upheld. And obviously all of that comes with a huge price tag, which I think they need to be probably a little bit more realistic about in Scotland at the moment. So an aspect of this is adequate resources, making sure you set up these these bodies with adequate resources, and so they can do their job effectively and appropriately. Second aspect of what has been suggested in Scotland is a due regard duty. And a due regard duty is literally a statutory duty to have regard to human rights when you're making a decision. So, for example, we have the public sector equality duty contained in Section 149 of the Equality Act of 2010. So it's been around for 11 years now, and this is the due regard to the need to eliminate discrimination and advance equality of opportunity. That's what public sector decision makers have to have regard to in their decision making. So the proposal in Scotland and elsewhere and is you also have this due regard duty for human rights. It's a duty of process and not outcome. It is, though, a reassurance to say the decision maker thought about human rights, took that into account before reaching their decision. Unfortunately, most commentators on the public sector equality duty have determined that it has been a failure, and that the way it's been interpreted and applied by the courts has drastically weakened what was intended. Courts are very wary about imposing what they call formulaic mantras, these hoops that decision makers have to jump through. And in recent years, there's been a real spate of litigation where the public sector decision maker will say, we didn't consider the public sector equality duty, but our decision wouldn't really have changed if we had considered it. And so the court will conclude, well, that's then okay. It's a failure to comply is cured because the outcome would not have been substantially different. It's very difficult to tell how a court can judge that, or even a decision maker can make that call that, or even if we took into account your human rights, we would have decided in exactly the same way. So these due regard duties are regarded as a bit of a disaster, and also the Scottish authorities are quite negative about a duty of due regard, although it's something they will include in their Bill of Rights. The final duty that's been proposed in Scotland is a duty to comply, and I find this actually quite bizarre. It's a duty to comply with human rights after a specified period. They're not clear at the moment whether or not it would be legally enforceable. And I see this as a very circular problem, is that there's already a duty to comply because it's in your Bill of Rights, and should you not be complying with that anyway, it seems to me in some ways an acceptance that the legal system is completely broken. And so we have a duty in our Bill of Rights that you haven't complied with, so we're now going to launch legal proceedings against you for your failure to comply. And it seems very, very circular. I still can't get my head around it. I think what's intended is that particular public sector decision makers, there might be something specific that they have a problem with, and then that's pointed out to them, and then they have to comply with that. But I still have a lot of difficulties in understanding how you're going to achieve clarity over what it's necessary to comply with. So there are three ways of going about improving how the state takes its duties generated by human rights, how we can move them further along the spectrum towards compliance. So I'm running out of time there, so I will finish up now, and I will say, so perhaps the answer is, alongside the Human Rights Act, we have a bill of state duties. And I think that's entirely unrealistic, given that the Human Rights Act is at constant risk of repeal, but it's maybe it's a way forward. A bill of state duties rather than a Bill of Rights or the Human Rights Act. My main purpose, though, is to understand and appreciate, of course, everyone gets excited talking about human rights. And so just in the last couple of days, we've had the UN Human Rights Council voted to recognise the right to a safe, clean, healthy and sustainable environment. But I think that is a major achievement. But while celebrating that, we should also be asking, how is that going to be realised? What duties are going to be imposed on the state to ensure that that right is upheld, and how important is and how can we move this particular right along the road so that the state takes the duties generated very, very seriously. So I say, of course, protect human rights, but accompany that with some kind of searching and realistic assessment of the corresponding and the equally important state duties. So I will finish there and happy to answer any questions.